All right, I'm advised that we are back on live. And Mr. Mohammed, thank you very much for your quite frank evidence and your revelations before us. We will await your further communication in writing as you have promised to do so. And Ms. Baglow and Ms. Peterkin, who I've quite justifiably described as the ever-efficient duo, will write to you in that regard.
Noted, Chairman.
Thank you very much. I propose now to move to the Fair Trade Commission. And just so that everyone, the very busy public servants, Ms. Khan, Mr. Ali, you must have extensive duties. We propose to break at 1 o'clock. We had intended to sit until 4, but unfortunately some of the members cannot be here until 4. So I don't intend to impose my tyranny on the rest of the members of the committee. So we propose to break. I propose to break at 1 o'clock. Mr. Narine-Singh.
Good afternoon, Chair.
Good afternoon. Thank you very much for your attendance once again. And I thank you. I wish to thank you for the documents which you've disclosed to us further to our inquiries. But arising out of that, I have some further questions, and my learned friends who are with me on the committee also have some further questions. Now, I have taken note of a recent public statement which you've made that the Commission is unable to act in the absence of a board. Am I correct? That's your baseline proposition?
Yes, Chairman, that is in terms of enforcement activity.
Right. So in terms of enforcement, that is your... Now, when did you lose a board?
The board would have resigned at the end of May of
2025.
2025, yes.
Right. So there are some issues which I wish to interrogate on that. So when you wrote the letter in December of 2025, you remember the letter you wrote to the Private Pharmacy Board?
It was December 2024.
2024.
Yeah.
You remember that letter?
Yes, yes.
In that letter, you basically told the Pharmacy Owners Association, let's call them loosely the Pharmacy Retail Board, right? That you were of the view that there was a prima facie case, you were of the view that there could be there was some evidence that they may have good reason to complain. Shall I get the exact terms of your letter? You will accept from me.
Chair, that letter was written in June of 2025.
June of 2025.
December 2024 was another letter, but June of 2025 was that letter. And that emanated, Chair and members of the committee, from an article in the newspaper. Okay. So that is where the facts and what I would have stated in that letter would have come out from. So that's in June.
So hang on. You wrote a letter in June of 2025 based on a newspaper article, facts contained in a newspaper article?
That there may be grounds to bring a complaint. That is what the facts would have, if I may, the facts would have demarcated and segmented the particular competition issues that would have arisen. Previous to that, we had gotten whatever information that was in the public domain, and which, and I'm glad Mr. Suchit is here, would have been saying was that there was a monopoly in the market. Now, that article would have indicated, and I'd like to just reiterate to the national community as well as to the members, the Commission is concerned with abuse of monopoly, abuses of monopoly. There are many instances in Trinidad and Tobago where there are entities with monopoly power. We are concerned with abuses. So that article would have indicated clear examples of where there may be abuse taking place. So that is why from the letter, that's how the letter initiated that.
So in June of 2025, you acting on a letter, on a newspaper article, which would have adumbrated several instances of conduct which could qualify as abuse of a monopolistic position, market abuse. You took that article and you wrote a letter in June of 2025.
Well, the article would have supported previous concerns that the Pharmacy Association would have said, like in the public domain and things like that.
What were those previous concerns that the article supported?
It supported that there, and if you want, I could refer to the article now. Could I?
No, we don't need to.
Okay. The article would have said particular pricing practices as it relates to the CDAP program.
Right. So let me ask you this. When was the first allegation of the abusive pricing practices in the CDAP program brought to your attention? Certainly it was not the article.
Yes, it was. No,
so,
we had never
hang
been,
on.
Yeah.
Did you not just say to me that the article somewhat corroborated previous allegations made?
No. It corroborated that there may be a monopoly going on. And then the issue now is if there's a monopoly, the concern now is whether there's an abuse of the monopoly taking place.
Okay.
So the issue is the abuse, not the monopoly itself. All the information that was previously disclosed would have been there's a monopoly, but the issue now is whether there's an abuse of the monopoly. And that article would have identified possible abuses, which is why we would have written to ask for some verification of that. And that is what emanated from the letter. And Chair, just to reiterate, we didn't have a board, but that would have assisted us in gaining preliminary information so that when the board was appointed, we didn't expect that 9 months later that there is no board, that would have been basis for the board then to guide us and give the appropriate instructions.
So, you have said that you didn't have a board and you couldn't act. Okay? On what basis you took this decision? Who did you consult?
Who did I consult? That was a decision I made to assist the incoming board in gathering relevant information, because that is what we have been doing still. We have been still dealing with stakeholders, and we still can receive complaints, but yes, we cannot investigate complaints. So when we got that information, I took it up on my own volition, and to also indicate that we have also been preparing various briefs to the Line Ministry as well, too, with respect to the work that we are doing as well.
All right. You had a board in September.
September
of 2024.
Yes.
You had a board from September until May. It's a period of 8 months. Okay?
Yes.
The first letter written to you by Mr. Young was in or around the 6th of September 2024. You agree with me?
Yes.
Did you take anything to the board when you got that letter?
The board was made aware that
by
concerns,
what means, might I ask?
In a meeting of the board, in a meeting, it would have been discussed.
Oh, no, well, hang on a second.
Yeah.
When the board, a matter is being put before the board, a board note is usually prepared, is it not?
Well, Chair, we did not prepare. I would have indicated to the board, because remember we were waiting information. That letter would have indicated they're completing work, and then they're going to provide us with the information. So when they provide us with the information, they'll give us a basis on then when to act. Because remember, they are the ones who have the industry knowledge, Chair.
Mr. Narine-Singh, I think we've been through the legislation to know that for the benefit of the public, okay? The Fair Trading Commission is a commission incorporated by statute. Your powers are outlined in Section 5, right? These powers are subject to the restrictions set out in Section 9, okay? And in Section 5(1)(a), it says very clearly, the functions of the commission are A, to carry out, subject to Section 9, on its own initiative or at the request of any interested person. What about at its own initiative disqualifies this?
Chair,
What disqualifies this case from the Commission exercising its power on its own initiative?
to investigate, it's not only, we have to investigate whether there's abuse of monopoly taking place, it's whether there's an abuse.
We accept all of that.
The evidence that were brought to our attention did not indicate that there's any abuse, and that's why we requested that a complaint be brought. The last time you said that this was a very complex document, so that is now, and we recognize that probably is at our end. We can simplify the process. So we would have requested that. Chair, we did not hear from anyone else anything from September until December when certain statements were made, and from that, the Commission, and you can see we have a timeline there if members could look at that. When we were aware of that, we realized that this is a very complex market. This requires significant work, and we would have written to the Line Ministry requesting that we get resources to assist us with a market study into the distribution of pharmaceuticals in Trinidad and Tobago. We would have sent that.
What is the date of that letter? That
letter would have gone to the ministry in January. We would have also requested to the ministry, because there's a timeline, so which we provided. And also, Chair, we would have also submitted as part of our public sector investment program submission to the Line Ministry that we get assistance to do a study of the pharmaceutical sector. Because this is a very, as you can see from here, it's a very complex sector. And if indeed we have to investigate, we need to have as much information as possible. And given our resources, I just like to reiterate that, we have very limited technical resources, right? There are three technical officers in the Commission, myself, a senior legal counsel, and an investigator. So we would need some type of assistance with respect to that. And we requested because we are very concerned, because we understand the importance of this sector to the national economy and to the lives of our populace, which we ourselves are part of too.
Okay. This is what you see in your letter dated 13 September. Mr. Young, who is the attorney, writes you on the 6th of September. You accept that?
Yes, Chair.
1 week later, this is what you see. Having reviewed the information that was provided, please be advised that as it relates to the oversight, investigation, governance, and enforcement of anti-competitive practices in the local healthcare and pharmaceutical sector, the Commission is the only authorized statutory authority to do so. I agree with you. Section 5(1) of your Enabling Act gives you the sole jurisdiction to do so. But this is what you go on to tell Mr. Young. However, please note that in order to formally begin the complaints procedure, the Commission requires that an official complaints form be lodged and submitted to the Commission. Where in your act says that you can decline to exercise your power in the absence of a complaint?
Chair, we did not decline.
I want you to tell me which statutory power provision in this act, number 13 of 2006, says that the Commission can only begin an investigation upon a formal complaint. Which provision in the act says so?
Chair,
which provision,
the
Mr.
Commission
Narine, Mr. Narine, I don't intend to quarrel with you,
no.
But it's a simple question to you. This is what you've told them. However, please note that in order to formally begin the complaints procedure, the Commission requires that an official complaints form be completed and submitted to the Commission. Which provision in the Act, and it's a very short Act, it's 53. It's 53. 53 sections. The enforcement investigation It's a very short chapter in the Act. Which provision requires a formal complaint? I want an answer to that.
We do not need a formal complaint. Didn't we agree the last time that we can initiate an investigation?
Certainly Section 5 tells you that.
Yes.
So what I want to know is why would the Commission fetter its power in such a manner that it would require a formal complaint procedure?
We did not require a formal complaint procedure, but to undertake an investigation, we needed to have evidence that there's an abuse of monopoly. So when we are investigating, Chair, it has to be an investigation based on anti-competitive practices. So it has to be based on abuse, in this case, an abuse of dominance. There was no evidence before us. And from that, if you notice, again, the timeline, from that, we have had meetings with various stakeholders.
We're going to get to those meetings,
into all of that. So we were doing that, Chair.
Mr. Narine-Singh, you're still not answering me. You say here, please note, however, please note that in order to formally begin the complaints procedure, the Commission requires that an official complaints form be completed and submitted to the Commission. What you're telling me here today is comparing apples to oranges. It's chalk and cheese. What you're saying today is that because it was an allegation of market dominance that you required it. This is what you tell the people, that in order to begin the process, you must first file a complaint. I am asking you simply, which provision in this Act requires a formal filing of a complaint before an investigation is launched? That's my simple...
It is not required, Chair, but we, at the same time, we did not have the evidence for us to go on our own volition and do and investigate, Chair.
Would you agree with me?
We were trying to get evidence, Chair.
Would you agree with me that the evidence comes at the investigative stage? Would you agree with me that that is the purpose of the investigation?
When there's an allegation of abuse of dominance, Chair.
Where there's an allegation of abuse of dominance, where is that in the Act?
What in section 17 to 18 to 21? We have the Act there. Let's go through that.
I do. I have it.
Right. So let's
go through it. Right.
If
17. Yeah. That is the chapter of the Act which deals with anti-competitive agreements or practices. Right.
Mm-hmm. Yes. Yes, sir.
So 17 is, so for the benefit of the members of the public, it defines what agreements are anti-competitive. You agree with me?
But yeah, I would point you more to section 20, monopolies, section 20. That area.
Right.
Section 20 to 21.
Right. And that talks about monopoly power, and it talks about abuse of the power and impeding maintenance and development of effective competition. But we get into all of that. Would you not agree with me that that is evidence gathered during the investigation?
If the evidence that is brought to us indicates that there's a monopoly, because we can't put the cart before the horse. First of all, you have to find out if it's a monopoly. Anytime we have, when these things happen, the other entities do come out in public saying there is not a monopoly. So the idea now is to find out if there is a monopoly.
How do you find out that?
Doing a proper market study, which we requested from the Line Ministry Resources to assist with that, Chair. Because we need to get, it's a very complex market. You need to get a lot of data and everything.
And that's my point. The anti-competitive monopolistic practices are only discovered in an investigation.
But we have to find out if it's a monopoly, Chair. And that is what we have to do first and foremost.
And your discovery as to whether a monopoly existing does or does not exist forms part of your investigation. So let me lay it out to you, okay? The first threshold you must cross is A, whether a monopoly exists.
Yes.
B, if no monopoly exists, no further investigation is required. You agree with me? The first rung of the investigative ladder is whether a monopoly exists. A monopoly exists if the circumstances described in section the 40% section. Okay, let's call it that. That is section 22, right? You agree with me?
Yes, yeah, if
Section
yes,
22,
yes.
3A, B, which describes several types of...
40%, yes.
Right. How do you determine the 40% if you don't actually start an investigation?
By doing a market study.
And what is a market study? Not part of an investigation?
No, Chair, because...
So what is that?
A market study is where we voluntarily get information. We do our inquiries to get the information. Oftentimes, we have done market studies before, Chair. When we ask entities to provide information to us, a lot of them, are we under investigation? Are we on, to go through a formal investigation entails significant resources as well. So the idea is to get the market, to get the information about the market first, which is why we had meetings with various stakeholders. And it's also important to note, Chair, right, that when we're doing this work too, it's very important because the market is so broad. We have determined to, it might be better to segment the market as well. So instead of determining if there's a monopoly in the whole pharmaceutical distribution sector, which is what the letter may have indicated, we would then probably try to segment to see whether there's a monopoly in the supply of pharmaceuticals to deal with cancer treatment, which is that kind of treatment.
When was your first meeting to discover market conditions? I'm going to get back to that afterwards.
Well, we would have had stakeholder meetings in the past where entities were invited to bring complaints about anything. When prices rose, we had done the last chairman had done a public notice about high prices as well too, and we would have invited entities to bring concerns to our attention. Right?
Now you've provided to us an agenda from Thursday, 17th October, 2024, which is 1 month after your 13 September letter.
Yes.
You agree with me? And in the absence of a formal complaint, you held this meeting. Okay? And one of the items which your chairman, Dr. Ramkisoon, addressed was proposed collaborative work with the Ministry of Health to address anti-competitive issue and the specific form in which this assistance is expected to be materialized. Mm-hmm. Did you at any time tell the attorneys acting for the private pharmacy board that this is what you were doing?
Well, Chair, we were giving them the liberty to, they told us that they would be, Mr. Young said he would be writing to us very soon, so we were eagerly awaiting that correspondence, and we never got anything. We have never gotten anything since that letter from Mr. Young. You know. All we got after was we saw statements being made, obviously, by Mr. Suchit. And from there, we acted, when in December, we would have then written to Mr. Young saying that we were expecting to get this letter, or this complaint, this follow-up,
yeah,
and we didn't get any. But we were acting, Chair. This is one area we have been doing our work. We have been trying to get information.
What I'm not understanding, Mr. Narine-Singh, is the Commission seemingly misplaced emphasis on the fact that it needed a formal complaint. Why didn't you all exercise your own ex proprio motu power in Section 5? And Section 5 is not the only place which says that the Commission may act on its own initiative.
Yes, Chair, but we have to investigate if there's a monopoly. Again, we weren't
Mr.
sure there was a monopoly.
I think you're putting the cart before the horse. Your determination of whether it's a monopoly comes as part of the investigative process. As I was pointing out to you, the first rung of the ladder you must determine whether a monopoly exists. Then afterwards, once that if the monopoly doesn't exist, then there's no way of going forward. But if the monopoly exists, and the monopoly exists where you could look at 22 objectively and get evidence on 22B, A, 3A, B, and C, and whatever it is, and then you move to the abuse and dominance stage. Okay? So wouldn't you agree with me that that's all part of the evidence gathering process in an investigation?
Chair, if we have to investigate,
Mr.
we have to investigate. We could do a market study to determine if you have a monopoly, but we have to investigate whether there's an abuse of monopoly. What we were trying to do all this time was to find out if there is a monopoly. And we needed experts, and that is the meetings.
So let's get to what you did then.
Yes.
So apart from holding meetings with the Ministry of Health and the Private Pharmacy Board, what else did you do?
We would have written to the ministry indicating we needed assistance with a market study, because Ministry of Health would have also written to us about some issues in January as well. We needed assistance with our market study. The cost that we estimated, the cost of our market study is over $1 million. Our budget, Chair, for the whole year, it's $2.3 million.
And what did the ministry say?
No responses, Chair.
So you wrote the ministry in January, something as important as a market study to determine whether there was a monopoly existing. No response.
Well, not if a monopoly is existing. As I said, it's a market study. We want to find out the distribution and who's the big players in the market. Yes, so that is what.
So where is that letter?
The letter would have been where we would have requested us from the media review, for the media review, funding from the media review.
Where is that letter?
It is supposed to be in the documents.
You've seen that? I haven't seen it.
Yeah.
I haven't seen it. Hang on a sec.
For the media review.
Just give me 1 second. Let me see if I could find that letter.
Yeah.
Let me see.
Pretty sure would you have it in your...
February the 12th?
No, February.
February 12, 2025.
February 12, 2025, sure. Sorry. Yes. Line Ministry for requesting additional funding.
This is yeah. All right, we have this letter dated February 12th, okay?
Yes, sir.
And in the letter, all this letter says is the Commission is seeking assistance from the Ministry of Trade for additional funding to engage a consultant to conduct market research and data analysis of the distribution channels within the pharmaceutical industry. It says nothing about pricing. It says nothing about anti-competitive behavior or abuse.
Chair, that's why we need to find, and you said we're going to get the monopoly. That will be used to get the data to determine whether there's a monopoly. And from that, then we will be then the questions about abuse. And we also wrote after that to the ministry for the mid-year review, for our public sector investment program. We also requested an allocation of $300,000 to assist with respect to that too. Chair, and prior to that, and I just want to mention this, put this on record, we had also made a submission to the Inter-American Development Bank because we had gotten grant funding from them in the past, and this would have been in 2023, I believe. We would have requested that we wanted a system with our market study. It would, and the whole proposal would have been like about 500,000 US, and we had identified pharmaceuticals as one of these areas where we needed assistance.
What I'm not understanding, Mr. Narine-Chattergoon, is were you doing that as part of your investigation, or were you doing that as part of the recommendations of the 20th PAAC report?
Well, we wanted as I said, since the IDB, we wanted information about that pharmaceutical sector for a long time, Chair.
Is it not true that the 20th PAAC report suggested that the Ministry of Health should request that the Trinidad and Tobago Fair Trade Commission undertake a comprehensive national study on medicine prices in accordance with Section 52B of the Fair Trading Act, Chapter 8113, and provide an update on this initiative? Isn't that the real reason you were asking for this money?
Chair, we would have started work since Mr. Young's letter, which was predating that. So we were concerned from Mr. Young's letter. That report was in 2025. Mr. Young's letter was in 2024. So from there, Mr. Young's letter would have precipitated us having meetings with various stakeholders. Because it was of concern to us.
Okay, so what you've just told me is that Mr. Young's letter was concerning enough so that it triggered a response within the Fair Trade Commission.
To get information.
Right, to get information. Okay. You had a board then?
Yes, we did.
Did you go to your board and say, Mr. Chairman, members of the board, look here, we have this letter. I think it's worthy of investigation. What do we do?
Well, Chair, it was not worthy of investigation for abuse of monopoly. It was worthy for us to get more information about the sector, which is why we had these stakeholder meetings. Okay,
assuming but not admitting you're correct on that. Okay? When you decided to take up the mantle on Mr. Young's letter and it triggered the response of the FTC, how did you convey this to the board? Did you write a board note? Did you write what did you do?
It would have been in the minutes. I would have mentioned it to the board. They would have,
the
letter would have been shared with them as well.
Under matters arising? Under any other business? Or did you make it a specific line item on the agenda?
Item, and from that, I would have recommended that let us have some additional meetings with stakeholders.
Where are those board minutes?
We can provide it if requested.
But we had asked for it on the last occasion.
A board minute of...
We did ask for a board minute where all of this was discussed.
So Chair, I would have then made a list of entities that we wanted to have further deliberations with. And we had these deliberations.
I am simply asking you that at the close of the last meeting, my colleague has a note of it. I did ask you specifically to provide the board minutes where this matter arising from Mr. Young's letter was discussed. Where are those board minutes?
Well, Chair, that will be provided. It will be provided. But
so
just to say, Chair, just to say, based on that letter also precipitated the work that subsequently happened as well too. We met with the Pharmacy Board of Trinidad and Tobago. We met with the Ministry of Health. We also met with the Medical Association as well. And Chair, one of the reasons why we did that, because Mr. Young in his letter said we would be hearing from him soon. So this was being done to prepare for that. When you send us correspondence indicating to me at least, that you have, you're going to share information about monopolistic practices or abuse of monopoly, we were eagerly awaiting that information. It never came.
Okay.
And we tried to, it might not have been but we indicated, well, if you're doing that, look the complaints form and bring it to our attention.
All right. So this is what you say in June 2025. Okay? The Commission is empowered under the Fair Trading Act to investigate anti-competitive practices and to ensure the maintenance of fair competition within the marketplace. Concerns about monopolistic behaviors, unfair pricing, and procurement irregularities within the CDAP may potentially fall within the scope of the Act and warrant further examination. What you meant by further examination in this letter?
Well, us examining whether indeed this is a breach of the Act, and Chair, just as I could, it's because the market is such a wide and broad market. This was the CDAP now. So at least now, if we have to do an investigation, it will be based on the CDAP as opposed to the overall pharmaceutical distribution sector.
So let's go on a little bit, shall we? In light of these developments, we wish to advise that there may be sufficient grounds. What you, as a lawyer with some experience, Mr. Narine-Singh, mean by sufficient grounds?
There may be. This could be an example. And where I want to know what is your appreciation. Section 21, Chair, right? What the Act is saying, right? This could be direct. As example, 21, and Chair, I don't want to compromise any work that we have to do subsequently to this, right? We have to be very clear if we have to launch investigations and entities like that. So I didn't want to demarcate, but Section 21(2)(d), if you see what that letter, what that correspondence, what that report would have indicated, 21, an example of abuse of monopoly, 21(2)(d), directly or indirectly imposes unfair purchase or selling prices, right? And that was what some of that may have indicated in that report. And that could have been an example of abuse of dominance. And that is where we could abuse of monopoly. Yes.
Right. So then you are of the view that there was some evidence to warrant further examination.
Well, based on the report, the newspaper report. Yeah.
Okay. But then you go on, you invite Mr. Young to have his client submit a formal complaint. You agree with me?
Well, that is what it would have indicated, yes.
Right.
Yes.
And you say, here's what you say. These records should indicate specific incidents and dates, supporting documentation, any material demonstrating the effects on the conduct of the business operations of the affected party. Please also be advised that the submission of a completed complaints form is required. This is what you say here. Is required in order to formally initiate the Commission's complaints procedure. Having come to the conclusion that there was sufficient evidence to warrant further investigation, why did the Commission not exercise its power contained in Section 5 to 9 throughout, acting on its own initiative?
Okay. Well, as you recall,
you had a board then?
No,
you didn't have a board.
No, have a board then. That's after
June,
the board.
yeah.
So that is obviously if the board is, and I will take instructions from the board. No,
Mr. Narine-Singh, your role is to advise the board, not to take instructions.
Well, advise the board if this is enough grounds to launch an investigation based on that. No, Chair. Basically, that the complaints form. Now, you see all this information that we asked for. The complaints form is itself a relatively simple document. It's that we asked for this, and that is what I have. When we met with the Pharmacy Retail Board Association, I would have explained that to Mr. Suchit and his team that the form does not, the form itself is not that complex, but the information may be, Chair. And what we have indicated is for all our applications, we are willing to work with the entity.
I accept all of that.
So
what I want to know is why does the Commission tie its power, bind itself to the receipt of a complaint when the Commission has the clear power to investigate and initiate investigations, conduct investigations on its own? That's what I want to know.
Well, Chair, I mean, basically, if you have to do these things, it's a lot of resources to do that.
Yes, I know.
And that is the reason. Any assistance we are appreciative of.
That's why you are the specialist body. That's why you are the specialist body. Because of the complex specialist nature of the work. The legislature has seen it fit to assign the investigative power to a specialist body. You are the only, and you've said so in letters, you are the only body able and empowered to investigate. And in recognition of that unique investigatory power that you have, the legislature has invested you with the power to investigate on your own initiative.
But
what
Chair,
I want to know.
Chair, not the resources.
Forget resources. We have to move from the first base. Forget resources. Why did the Commission tether itself to the fact that no formal complaint was made when it had the full power to investigate the complaint on its own, having found that there was sufficient grounds to do so? That's what I want to know.
The sufficient grounds only came in June.
That's besides the point, Mr. Narine-Singh.
The sufficient grounds came June long after a board had left.
Right.
This is where the sufficient grounds
is. There anywhere in this letter did you tell them that no board, whilst you are of the view that the Commission can investigate on its own, you are awaiting the appointment of a board?
No, I did not say that.
Rather than do that, you told this organization that yes, you may have grounds, but you had to come and file a complaint first. That's what you did.
But we are willing to assist in the complaints process too, Chair.
Mr. Narine-Singh, all of that is irrelevant, quite frankly, with respect. With respect, quite frankly, all of that is irrelevant. Essentially, what you told these people is that the Commission will not act unless it receives a formal complaint. Do you not agree with me that that is the purport of this letter? That is what you tell them. Do you not agree with me?
We are hesitant to act without
Mr. Narine-Singh,
yes.
Your hesitancy is quite frankly irrelevant again. Is it not true that what you told these people in this letter is that you are not prepared to act and exercise the power of the Commission without the receipt of a formal complaint? Isn't that what you tell them there? The answer to that is yes or no, you know. You know this letter better than any one of us. So the answer to that question is either yes or no.
Well, Chair, the idea is to get the information. And when the information is received, we will advise the board. As I said, I have to advise the board. I will advise the board.
So let's get to the getting of information. And we go now to the power of the Commission. So at Section 8, at Section 7, okay? Section 5, we know what Section 5 says. Section 7 says, in pursuance of its functions under Section 5(1)(a), the Commission may investigate the affairs of a business enterprise if after consideration of a complaint from any person that the business enterprise, right? That's A. 7(b) says, on its own initiative having regard to facts available to it.
Well,
it
Chair-
is of the opinion that the business enterprise is acting in contravention of this act.
Okay, so Chair, first of all, I'm glad you raised that there. 7(1)(b), on its own initiative, having actually facts available to it. We have no facts available to us that there's abuse of monopoly, one. And second, is of the opinion that the business enterprise is acting in contravention. You have to identify the business enterprise.
Hang on. Earlier in this exchange, you told me that you relied on a newspaper article and the facts contained in a newspaper article, which prompted you to write this letter of 17 June. You rely on that? You
Yes,
recall that?
yes.
Okay? So that's part of that 7(1). Okay, I accept the niceties you're trying to draw here. And whether that is so or not is a matter for interpretation. But let's move on a little bit. Right? We go to 8. And 8, the side note to 8 is powers of the Commission with regard to investigation. For the purpose of conducting any investigation with regard to the discharge of any of its functions under this Act, the Commission shall, subject to subsection 2, have the power to A, require the production of documents for examination, B, require any document to be verified to the Commission and to be verified by affidavit. And you know why they want you to submit by affidavit? So that if you swear a false declaration, you can be prosecuted for perjury. Right? It serves a legitimate public purpose in the Act. And C, summon and examine witnesses on oath. 2, this is the breadth of your power. The Commission may, for the purpose of enforcing the attendance of any witness, apply to the court for the issue of a summons for attendance of the witness and for the production of any document, book, and related matter. Okay? But yet, having regard to those wide powers contained in the Act, in your letter of 17 June, you tell the Pharmacy Retailers Association that you require a shopping list of documents. Can I pass it? You have it? A shopping list, you virtually give them a shopping list of 9 things you want. 11. All documents, data, and information in the affected party's possession. Copies of statements, complaints which have been submitted to industry, a description of the relevant facts, information about the business enterprise or individuals involved in the conduct, the nature and scope of the business activities, indication whether a relationship exists between the legal entity or natural person, identification of the main competitors, when any action has already... I'm not going to waste time and go through that. All of that information, the Commission had the power to get pursuant to Section 8, acting on its own initiative. Wouldn't you agree with me?
We do if we have an allegation or entity that is alleged to be...
So what, we go back now...
committing anti-competitive practices and abusing their monopoly.
So we go back now to what is the meaning of sufficient grounds?
You have first of all, you have 40%, at least 40% of the market, and secondly, you are the grounds in Section 21.
What were you exactly?
Yes.
So that in your letter, when you told Mr. Young that in light of these developments, we wish to advise that there may be sufficient grounds for members of the private pharmacy retail business association to submit a formal complaint. Sufficient grounds meant that there were sufficient facts known to you at the time writing this letter, that the conditions on Section 20 and Section 22 existed.
That the facts are, the article would have indicated that the entities there's a dominant position in CEDAP.
Point.
And secondly, that the certain practices that were mentioned there in terms of pricing was there. We did not have any evidence of that, Chair, prior to that.
Right, so when
and that's
you
why,
wrote
and
this-
Chair, we try to, and this is why it was, as we to CDAP, that letter indicated CDAP to her. It didn't indicate
This
just...
letter indicated that they had sufficient grounds. But this letter also indicated that the commission was not prepared to do anything until it received a formal complaint.
Well, Chair...
The simple question we want to ask you, Mr. Narine-Singh, is why did the commission tether itself to the receipt of a formal complaint? Why? When the statutory power doesn't say so. It lays down
Chair.
no such it lays down no such formal requirement.
Well,
You are the commercial policeman, you know. This is what you are. You are the policeman of the marketplace. And in effect, you are saying that abusive behavior could take place and you could just simply turn your eyes without a complaint.
Certainly not, Chair. And that's why
That's
we were
what this letter says.
Chair, we also have to be constrained by administrative law as well, as you know. We cannot be acting unreasonably and irrationally as well. So as much information that we can get, we will be subject to that too. If we launch an investigation, you don't think, well, we can't launch one now, as I said, because we don't have the board yet.
Yes,
but prior to that, if we were to launch, we may have been guilty of acting. I'm just saying, if an entity would come, the entity being that is being where the complaint, who we are going against, they might make the argument that we are acting unreasonably and irrationally. Chair, we also have to adhere to administrative law principles, as you know too.
Yes,
So,
I'm very well aware of that.
And we did not have any information. We all is that we got a letter from Mr. Young saying that he was going to.
Mr. Narine-Singh.
Mr. Young saying that abusive practices are taking place. You will hear from us soon. They're compiling. Did not get anything. After that, within that period, we were meeting with stakeholders to find out if indeed that is happening. Then we would have gotten information. Well, the letter would have been sent in December. We got our next letter. I'm sorry, Mr. Suchit would have said some statements. From that, we would have gone to the line ministry and asked to get this information.
We understand all of that. The simple question to you is this. When you wrote to them and told them that there were sufficient grounds, why did you tether the power of the commission to the receipt of a formal complaint? It's as simple as that.
Well, Chair, we are waiting on a board, and I did not want to advise the board whenever it's appointed, let us start this investigation, because that would be the what I would advise the board. Remember, we have no board, so this would have been in June. So when indeed the board would come in place, I would have advised, and I would still advise. It's very difficult to launch, although legally we can do it. It's very difficult to launch an investigation of this nature without sufficient data and information. But if the board is so minded, we will indeed launch the investigation.
The commission has very wide power.
Well, I will explain
Section 7
yes.
and Section 8.
Yes, and I will explain that to the board, yes.
Right. But instead of telling the association that, you chose instead to tell them, we're not prepared to do anything unless you lodge a formal complaint. Essentially, the commission through you, Mr. Narine-Singh, was washing its hands of this matter unless you received a formal complaint. This is what your letter says. You can put whatever spin you want on it, but your letter says,
Well, Chair,
I'm not prepared to do this.
I have to protect the board. I have to protect the organization as its chief executive officer from potential legal ramifications if indeed we take our action and we have no grounds and we've been acting unreasonably on irrational and we have to end up paying costs. Chair, this is the reality. and we have to end up paying cost to our party.
Now that we're getting into the realm...
The resources, our resources are very limited, Chair.
Now that we're getting into the realm of administrative law,
Yes.
you will also know the principle of deference in administrative law, where courts accord a high level of deference to a specialist body exercising a power within the remit of that specialist body. All right? So let's not talk about irrationality in glib terms.
In competition law, Chair, and our agency, I'll just give you an example. The U.S. Federal Trade Commission launched its first investigation after its 12th year in operation. We are only 5 years since the full proclamation of the Fair Trading Act. For us to do something like that, yes, legally we can do it, but we have to be very careful in terms of resources as well too. In terms of launching, so Chair, let us guess what was before us. We got a letter from an entity saying that there may be anti-competitive practices. You will hear from us soon. We did not hear from them. Prior to that, we would have met with a number of stakeholders. In January, and then the following year, we would have written to the line ministry for us to get resources to assist us. Chair, this is a very important sector to us. So I would not say we are deferring with the sector. The sector is critical to national development. And we want to do it properly.
All of that, you know. The singular question that is occupying the last 15 minutes of this discussion is why did you tether your exercise of your jurisdiction to the receipt of a formal complaint? That's all I'm asking you.
Because, Chair, we have to understand what is the exact abuse that is happening. We don't have the evidence. And in June, we got some evidence where there's setup, there's possible practices there.
So despite telling, what you're saying to this committee is, despite telling the association there was sufficient grounds,
there may be sufficient grounds, sir. That's what it said. Sir. So we need to get some more details about that. And that's why we was hoping that they could provide us with that. But subsequent to that, Chair, we have also met with the association. We have met with them. We have a working relationship now. So that is what we have been doing in the last few months as well too. So we have not been.
Mr. Narine,
yes.
Let's end on this, right? So we think that please also be advised, and we're dealing with plain English here. Please also be advised that the submission of a completed complaints form is required in order to formally initiate the Commission's complaint procedure. That's what it says. It doesn't say anything other than the fact that we are not prepared to do anything until you submit a formal complaint. Wouldn't you agree with me that that's what that sentence says? It's a simple sentence, you know.
Well, Chair, until I get aboard, that is my position right now. But the board, when we will have all whatever information is before us, the board could then, and I will advise the board the options, and we can go ahead.
I really am at pains to understand what part of that sentence, a simple sentence, makes reference to the fact that there is no board and that it will change when a board is appointed. You have bound the exercise of the power of the Commission to a condition precedent which does not exist in law. There is no condition precedent in law which says that the Commission cannot act in the absence of a formal complaint. None.
But it needs that. We need to launch an investigation, Chair. We need the board. So we can receive complaints. We can receive that. But to launch the investigation.
That you told these people that you will not act unless a formal complaint is submitted, where no such condition precedent exists within the four walls of your enabling act. That's what I am on. Why did you fetter the jurisdiction of the Commission? when you had no power to do so?
We did not fetter, Chair. We have
So
to
what
get
does
information.
this sentence
have
mean?
to launch.
Please also be advised that the submission of a completed complaints form is required in order to formally initiate the Commission's complaint procedure. What does that mean?
Chair, because there is, what I could have added, it is, based on what is before us, there is not grounds for us to launch a formal investigation into abuse of dominance by an entity that has not been named, and what they're doing. That is what I could have added.
So what did you mean by saying, in light of these developments, we wish to advise that there may be sufficient grounds for members of the Private Pharmacy Retail Business Association to submit formal complaints to the Commission regarding potential breaches of the Fair Trading Act? What breaches were those?
Well, first of all, you have to identify the entity that is supposedly
Hang on a second.
doing that.
What were the breaches of the act you were referring to there?
Yeah, the section 21 to 2020.
Exactly.
Yes, that. Because the article would have indicated there have been allegations of that, but no one had put specifically who was doing it, which particular entity is doing it. And so we were just waiting to get that document, Chair. And
why, having come to the conclusion in this paragraph, which is a paragraph comprising one sentence, that there were potential breaches of the Act, you then told the association that the Commission was unprepared to act in the absence of a formal complaint, when no such statutory power, no such statutory provision fetters your power, the exercise of your power.
No, Chair, but we didn't have information. We still didn't have the information.
I accept that that is your position.
And we're trying to get this information.
The committee will make what it wishes.
We are attempting to get this information, Chair.
The committee will analyze that, and we will come to a finding on it and make recommendations. I thank you very much. At this stage, I think it's 1:30. I've gone past 1 o'clock, as I promised before. We are going to formally adjourn the meeting at this stage. You did promise us the board minutes in which this matter was discussed. We would look, Ms. Peterkin or Ms. Bagalu will write you in that regard, and we will get it. The next date is proposed. We will get in touch with everyone by the end of this week. By the end of this week, and we will give you the next date, proposed date of hearing. I want to thank everyone. I'm sorry for the inconvenience, but as you can see, it is an important inquiry. There's a lot of ground to cover yet, and I think it's an inquiry which serves the public interest well. So thank you all very much, and we will see you at the next session. No?